A back or a spinal cord injury doesn't just hurt, it rewrites your life. It changes how you work, how you sleep, and how you move in everyday life. If this happened to you because of someone else's negligence, you should not be the one carrying the cost of it. I am Asthana at Caldwell, Wenzel and Asthana, personal injury lawyers. We represent spinal injury victims across Alabama, Mississippi, and Florida. And I want to walk you through everything you need to know before you make a decision about your spinal injury case. Spinal and disc injuries happen in more types of accidents than people realize. Car and truck accidents are the most common, but we also see these injuries from motorcycle crashes, slip and falls, pedestrian accidents, workplace injuries, and construction site incidents. If someone else's negligence caused your spinal injury, it may be a claim worth pursuing. Spinal injuries cover a wide range, and the severity is not always obvious right away. On one end, you have herniated discs, disc bulges, and compression injuries. These can cause shooting pain, numbness, and long-term nerve damage. More serious injuries involve the spinal cord itself. Partial spinal cord injuries can cause weakness or loss of function, and complete spinal cord injuries can cause paraplegia or quadriplegia. But here's something that most people don't know. Some of the most painful and disabling spinal injuries, including facet injuries, spinal instability, and nerve damage, don't always show up clearly on an MRI. If the insurance company tells you that your MRI looks normal, then that does not mean that that injury doesn't exist or that you don't have a case. If you suspect that you have any of these injuries, getting an evaluation from an interventional pain management specialist or a physical medicine and rehabilitation doctor can help with further treatment and building the record that will enhance the value of your claim. Now, there are a few things that consistently hurt spinal injury cases, and I want you to know them. Delaying medical treatment even when your pain feels manageable. A gap in medical care gives the insurance carrier room to argue that your injuries were not that serious. Accepting a sprain or strain diagnosis from the ER without following up with a specialist. Emergency rooms use those labels of sprain and strain routinely. Those labels do not tell the full extent of your injuries. The value of a case with the labels of sprain and strain is far lower than what it could have been had you had the full extent of your injuries documented. Giving a recorded statement to the at-fault party's insurance carrier before consulting with an attorney. And accepting an early settlement offer before you even know the full extent of your injuries. Spinal injury cases often require injections, nerve blocks, surgery, and follow-ups. These procedures can take years. Even without a surgery, the cost of lifelong pain management, physical therapy, medications, and chiropractic care all adds up to an enormous amount of money. Settling early can leave you without the resources you need to cover what's coming next. And last, do not post about your accident on social media. That evidence will be used against you. Spinal injury cases have a high value, and that is why insurance companies fight those cases really hard. They have a playbook that they use every time. They will argue that your MRI shows degenerative changes, not a crash injury. Degeneration just means aging. Everybody has some. It does not mean that the crash did not cause you injuries or worsen your pain. Knowing the true value of your case, they will make very low early offers hoping that you will take them. This offer will not even come close to the future cost of care for your injuries. But having experienced legal representation will change what you are able to recover. The law that applies depends on where your accident happened, which resulted in your injury. If it happened in Alabama, Alabama law applies. Something to note about Alabama is that it follows a pure contributory negligence rule, which means that if you were even 1% at fault in causing the accident, your case is barred. Florida follows a modified comparative fault rule, which means that if you were 51% or more at fault, your case is barred. And Mississippi follows a pure comparative fault rule, which means that if you were 99% at fault, you can still have a chance to recover for that 1%. In Alabama and Florida, you have 2 years from the date of the accident to either resolve your case or file a lawsuit. When it comes to Mississippi, that's 3 years. That might sound like a long time, but please do not wait. If you miss this very strict deadline, you will have no case. At Caldwell, Wenzel, and Asthana, we give spinal injury cases immediate, focused attention. We move fast, we investigate and preserve evidence before it disappears or memories fade. We work with medical experts to document your injuries and its full lifelong impact. This includes future surgeries, rehabilitation, pain management costs, and any permanent changes to your ability to work and live your life. We handle all the communication with insurance companies so you're never navigating that alone. And if the insurance company refuses to make a fair offer, we are ready to take your case to trial. Our clients pay nothing unless we make a recovery for them. So if you or someone you love has suffered a spinal injury in Alabama, Florida, or Mississippi, call Caldwell, Wenzel, and Asthana for your free case evaluation. We look forward to working for you.